The Fourth Amendment to the U.S. Constitution provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. An arrest constitutes a seizure of a person, so the restrictions of the Fourth Amendment also apply. It is worth noting that neither the perception of the person detained nor the officer determines whether a seizure has actually taken place. Instead, the trial judge or jury determine whether a reasonable person under the same circumstances would consider the situation to be a seizure. It is important to note that there are some contacts with the police that are so minimally intrusive that they are not considered to be seizures. For example, the police are free to ask questions of people on the street in order to gather general information. Also, the court has ruled that the police may board a bus and ask questions that a person is free to refuse and to answer. And police may also ask a driver to get out of a car after being stopped. None of these contacts would be considered to be a police seizure. Seizures are usually associated with an arrest. However, an arrest is only one form of a seizure. Stop and frisks, border searches, and roadblocks are seizures that come under the Fourth Amendment, but the constitutional requirements for these types of police actions differ from those of an arrest because they are a lesser form of intrusion. For example, we know from last week's discussion that an officer only needs reasonable suspicion to conduct a stop and frisk, which is a lower standard than what is needed to make an arrest. So one could say that every arrest is a seizure, but not every seizure is an arrest. Before we continue, allow me to first provide a definition of what constitutes an arrest. Most legal experts would agree that an arrest occurs when an individual is taken into police custody against his or her will for the purpose of criminal prosecution or interrogation. The person's liberty must be restricted in a manner where a reasonable person would not feel free to leave by his or her own volition. Four essential elements must be present for an arrest to take place. First, there must be seizure and detention. If an officer tells an individual, "You're under arrest," this alone is not sufficient. Rather, there must be an actual restraint of the arrestee or peaceful submission. Next, there must be an intention to arrest. If an officer places handcuffs on an individual, a reasonable person would infer that he or she is under arrest. Another element of an arrest is that the person arresting must have the authority to do so. Whether or not a police officer has arrest authority off-duty varies from state to state. Some states authorize police officers to arrest any time they witness a criminal act. Finally, the last element of an arrest is that there must be an understanding by the individual that he or she has been arrested. The element of an arrest is not required, however, when an arrestee is intoxicated or under the influence of drugs. Interestingly enough, in some states, an arrest is required for particular traffic offenses, while in others, an arrest is left to the officer's discretion. Other states do not authorize arrests at all for traffic violations, and instead officers are only permitted to issue citations. Still, it is important to point out that the Fourth Amendment does not forbid a warrantless arrest for a minor criminal offense, such as a seatbelt violation, which is typically only punishable by a fine. It is important to note that 95% of all arrests are made without a warrant. Nonetheless, there are specific instances when a warrant is needed. For example, if a crime is not committed in an officer's presence, the officer will need to present an affidavit to the judge or magistrate to ask for a warrant to be issued. If the judge or magistrate concludes that probable cause indeed exists, only then can the warrant be issued and served by the police. There are exceptions to this. Emergency circumstances, for instance, may make it necessary for the police to take prompt action in order to prevent a suspect's escape. Also, the U.S. Supreme Court has held that the police officer must be able to obtain a warrant if making a felony arrest in a private residence when there is time to obtain a warrant. Generally speaking, felony arrests may be made at any time, day or night. Misdemeanor arrests, on the other hand, are usually made during the daylight hours. However, in some states, an arrest for any crime, felony or misdemeanor, can be made at any hour of the day or night. In virtually all states, the issuance of a warrant is strictly a judicial function that must be done by a judicial officer who is neutral and detached. This means that the person issuing the warrant must not be aligned with either the police or prosecutor's position in the case. Sometimes a John Doe warrant may be issued. This is when the name of the suspect is unknown. When executing a John Doe warrant, there must be a detailed description of what the suspect looks like. Otherwise, the warrant will be invalid. It is worth noting that besides executing the arrest warrant, a judge or magistrate can also issue a bench warrant. This is a writ that is used to arrest and bring non-appearing defendants before the court. So, for example, if a traffic offender was issued a citation for reckless driving and told to appear in court and was not taken into police custody, a judge or magistrate might issue a bench warrant if the driver failed to appear at their scheduled court date. Earlier it was mentioned that the overwhelming majority of arrests do not take place with a warrant. For example, if a felony or misdemeanor is committed in the presence of a police officer, then a warrantless arrest can be made as long as the officer has probable cause. Interestingly, the officer can use any of his 5 senses in order to make an arrest. So, for example, if an officer smells marijuana smoke during a routine traffic stop, this coupled with other evidence may be sufficient to make an arrest. Generally, taste is the least used of the 5 senses. In fact, some departments do not allow their officers to use taste at all, and instead provide them with packets that they can use to field test suspicious substances. Police officers are also permitted to make warrantless arrests in public places, as these have minimum protections under the 4th Amendment or right to privacy. However, if an officer is in hot pursuit of a suspect, he or she is generally permitted to chase the suspect into his or her home and make an arrest. This can also be done if police believe that an occupant within the home is seriously injured or being threatened with an injury. For example, if a police officer responded to a call about a loud party at a residence and upon arrival heard shouting and believed that a fight was taking place, he might be permitted to intervene even if this means opening a closed door and entering the dwelling. When the police arrest an individual, they are permitted to search this arrestee regardless of the offense committed. Under United States v. Robinson, this is totally permissible, and a search incident to arrest requires no further justification. In a related U.S. Supreme Court case, Chimmel v. California, the court held that the police could also search an arrestee's immediate area of control, which is also known as a person's wingspan, meaning the area covered by the spread of the suspect's arms and hands. If the search goes beyond the immediate area of control, the officer must obtain a search warrant. If an arrest is made in a suspect's home, the police are generally permitted to conduct warrantless protective sweeps, which permit officers to look at rooms or places within the house other than where the arrest was made. Protective sweeps have been permitted because it is believed that these enhance officer safety. When a suspect is arrested in or around his vehicle, officers are permitted to search the vehicle that a suspect was riding in. In fact, as alluded to earlier, police officers may search a vehicle even if the suspect was not in the vehicle when arrested. Police officers are also welcome to search the passenger glove compartment of the vehicle as well. However, they may not search a locked glove compartment or the inside of the trunk of a car unless they have a warrant. Police may, of course, handcuff the arrestee, as they often do. However, the Supreme Court has yet to address the issue of handcuffs, so this tends to be guided by both departmental policy and officer discretion. Police may not use unbridled force during an arrest. If an officer uses non-deadly force, which is unlikely to result in serious bodily injury or death, it must still be reasonable force, meaning that a prudent and cautious person would use it if exposed in similar situations. Deadly force, on the other hand, occurs when there is a high likelihood that an act possesses a high risk of death or serious injury. It is constitutionally reasonable for a police officer to use deadly force when the officer has probable cause to believe that a suspect possesses a threat of serious physical harm either to himself or to others. The court in Tennessee v. Gardner held that a police officer may not shoot an unarmed suspect who possesses no threat to the officer or others. This struck down the fleeing felon statutes, which were prevalent in almost half of the states during the early 1980s. Today, courts have turned their attention to tasers, electronic weapons that shoot barbs which deliver 50,000 volts of electricity to the body and incapacitate the target up to 25 feet. Courts have by and large ruled that the use of tasers by police officers are permissible so long as they are utilized in a reasonable manner.